Hi, this is Steve Hubbard with AMVSR LLC. On the left is the YouTube video of this conference hosted by the North Carolina Commission on the Administration of Law and Justice held on December 2nd, 2016. On the right, this video clearly demonstrates near perfect transcription when the best microphones are used and properly used. From time to time, I will be adding voiceover comments. After downloading this or any other video clip to your PC or Mac, please use either RealPlayer or QuickTime as your viewing player, and maximize the screen, and do not be afraid to experiment when invited to do so.
Thank you all for being here today. It's really exciting for us in the Commission staff, and I know for all of you to be together one last time. And we are thankful for the opportunity that we've had to work with you and serve you. I think speak on behalf of Emily and Roxana, and it's been a delight working with all of you. You can imagine just getting to interact with all of you on a regular basis. It's been very rewarding for each of us.
This presentation format links the soundtrack to each word and also highlights in yellow. This form of open captioning assists those who are hard of hearing, as well as for members of the public whose English, written and oral skills are not up to par. They hear the word or phrase and also benefit by seeing how specific words are spelled.
It's been a delight working with all of you. You can imagine just getting to interact with all of you on a regular basis. It's been very rewarding for each of us. I want to thank you personally for that. So we're going to go ahead and get started with our afternoon program. If you could join me in putting your hands together for our Chief Justice.
Well, good afternoon. I think it's amazing how really this large of a group, how organized we've actually been. I mean, everybody was able to get through the line, and here we are. And several have told me they need to leave early, and I totally understand. And we're going to try to really move the meeting forward expeditiously as well. And so welcome to the final meeting of the Commission on the Administration of Law and Justice. This is a very special day, and we have a number of special guests with us today who have really made not only this day possible, but the work of the Commission possible.
RealPlayer and QuickTime. Note the horizontal scroll bars in the bottom of the frame. Quickly jump through the transcript, and upon finding a paragraph or a specific yellow highlighted word that starts the critical passage, simply click and play.
Jonathan Mattiello is Executive Director of the State Justice Institute and has traveled from Washington to be with us today. Here's Jonathan.
Yes, ASR transcriptor makes bloopers, but so do conventional court reporters and PC keyboard transcribers. But unlike any other transcribing modalities, ASR transcriptor, if not in real time, will transcribe 7 hours on a video or audio record in less than 1 hour for a fraction of the price.
And I'm not sure I've seen Sheriff David Huffman. Is he with us today? All right. Well, David has done so much for us, and of course is Executive Director of the Governor's Crime Commission. The general financial contributions of SJI, the Governor's Crime Commission, and Z. Smith Reynolds in helping underwrite and support the work of the Commission cannot go without mention this afternoon. And we are so grateful for this federal, state, and nonprofit partnership in support of the Commission. Let's thank all three organizations.
It is imperative that chief judges, court administrators, and the rest of the courthouse campus upgrade their digital recording systems to devices like these.
We're also very fortunate to have Dr. Peter Kohling of the American Bar Association with us today. And Peter, could you stand? And Peter, we thank the American Bar Association, and you've been with us every time, and we so appreciate all your help in support of the work of the Commission. We're also grateful to so many people who've contributed their time and energy to the success of this commission. Let me start with all the commissioners. Commissioners, I'm so grateful to each of you for all you've done in support of this effort. I thank you personally, and I also thank you on behalf of the judicial branch of state government and the people of North Carolina. Thank you very much. And the weighty task of this commission has required the efforts of every single person in this room. As you know, it had been 20 years since the last effort to improve the administration of justice in North Carolina. And I'd guess that after your last 15 months of work, each of you has a greater respect now for the work of both the Medlin and the Bell commissions. You've done a tremendous job on building on the foundation of these previous commissions. Now that your job is done, the most practical way that I can show my appreciation for all that you've done is to give you my word that I will do all that I can to see the recommendations of this commission implemented into law. And the good news is that we can do much of it ourselves within the judicial branch. And in those areas where we need to partner with the General Assembly, we will give 110% to try to make sure that those recommendations as well are enacted into law. Now, at this point, I'd also like to thank the commission's staff. Will, Emily, Roxana, we all thank you for all you've done and for continually keeping us organized. Let me also take a moment to thank some of the many folks who work behind the scenes. The AOC research and planning staff were literally kept on their toes with the Commission's constant requests for data. Brad Fowler, Danielle Seal, Kurt Stevenson, thank you so much. Also, thank you to Sharon Gladwell, Communications Director at AOC, for publicizing all of the Commission's good work. Now, after Sharon organized us the way she did for that photo shoot today, I think we need to give her a special round of applause. As you can see, she really keeps me on my toes. I think I've had to pull up my tie about 5 times. But also, the folks at the NC Bar Association for keeping our state's attorneys in step with the work of this commission. Jim Phillips and Mike Mitchell with the association's AOJ committee, Shelby Benton and Kearns Davis in their leadership roles, Courtney Denny in her job staffing efforts, and of course, Alan Head. Now, where is Alan? There's Alan. Alan, your service to our profession in North Carolina is unrivaled, and we're really going to miss you, and I just want to thank you. I know we all want to thank you. But we are glad that since Alan has to leave at this point, that the Commission's own Jason Hensley will be stepping into that role. And Jason, we congratulate you. Where's Jason? There we go. I also want to thank the NC State Bar for being supportive of the Commission's work, especially the ongoing dialogue within the Legal Professionalism Committee. I'm sure that there are others that I've left out, but let me add my thanks to everyone over at the UNC School of Government for your guidance and input in so many ways during so many of the Commission's conversations. If any of you that are here today, please.
How many offices of the public defender, legal aid, and pro bono volunteers, lawyers around the country, strapped with precious little resources, wouldn't love to have access to instant and daily copy verifiable multimedia transcripts like this for 20% of what they would normally pay and better represent their clients' constitutional rights?
Please stand as I call your name. Dean Mike Smith, Tom Thornburg, Jeff Welty, Mike Crowell, Jim Drennan, John Rubin, and many others, whoever's with us today.
The 3 million voice-to-text entries in the ASR dictionary has unusual spellings of people and places.
Now, I intentionally haven't mentioned the School of Government's Professor Jessica Smith because she and all of the other reporters deserve a very special word of thanks. Professor Smith, Professor Miller, Matt Sawchak, Mildred Spearman, Andrew Atkins, Kurt Stevenson, and Paul Embley. It's no secret that each of you has shouldered a significant component of the work of this commission. And I know that the committee chairs will each express their gratitude to you in a few minutes, but I wanted to be the first. Will you please stand so we may recognize you for your service?
Perhaps now is the time to do our first experiment. I'm assuming you have downloaded the video and are using Real Player or QuickTime. From this position, where the scroll bar is, stop the video. Note the time on its timeline. Quickly advance the bar to the right by several minutes and stop anywhere at random. Note the time where you stopped. Pick a paragraph and a word within that paragraph and take note of the word. Now go back to roughly where you were initially and stop. Now, using the bar, slowly advance through the transcript until you come to the general area where you were and slow down until you land on the exact word. Suppose you had to play this question or answer to the judge who is hearing an emergency motion the next morning, and you will do it with pinpoint accuracy. And so far, you have paid for is an interactive working rough draft that you are sharing with opposing counsel, as well as the cost. Hopefully a judge would agree with counsel's stipulation. Yes, I understand the parties have stipulated you are able to save your client's resources, and you have what appears to be an interactive transcript that serves everyone's purposes, including the court.
This is the fourth and final time that the full commission is meeting together. As commissioners, you're well aware that you need to be informed about the work of the other committees so that you can effectively advocate for the commission's recommendation in your spheres of influence. At our December meeting at the School of Government and at our June meeting at the NC Bar Center, each of the reporters provided updates on their respective committee's work. For this last meeting, we've asked each of the chairs to give an update as to their work. The committee recommendations track closely enough with the earlier updates from the reporters that we have agreed that formal presentations weren't necessary for a third time. Rather, the chairs will provide a brief overview and the highlights of their committee's work and recommendations. With your last committee meetings finishing up just 2 weeks ago, the ink is still drying on each committee's final reports. So our timing for these updates from the chairs could not be better. We'll start with the first committee, alphabetically. The Civil Justice Committee benefited tremendously from the skillful insights and steady hand of Dean David Levy, Dean of Duke Law School. He graciously hosted the committee's meetings at the law school, and the committee also enjoyed rigorous academic support from law school faculty, including Professor Darrell Miller, the committee's reporter, and the research assistants of some of the school's students. David has brought to his committee's work his perspective as a former United States attorney, a former federal judge, and now as Duke Law Dean. We're so lucky to have had his leadership on the committee. Dean Levy, please come forward to give the report, and let's give Dean Levy a round of applause.
Thank you, Chief Justice. This is the season for giving thanks, and I'd like to give some because truly we're very grateful. First of all, I'd like to thank my co-chairs in this endeavor. We met from time to time and on the telephone, and I always found your insights so helpful. I'd like to repeat the thanks offered to Will, Emily, and Roxana, the commission staff. Just excellent support. Thank you. And then the AOC as well, Judge Warren, John Williams, Brad Fowler, and Daniel Seal. Thank you very, very much. And of course, the individual members of my committee, one always looks for a setting in which you are looking for people to work with who are bright and well prepared and who are public spirited. And in this committee, Mr. Chief Justice, you appointed such people, and it was really a joy to work with them, with Janet Ward Black, A.P. Carlton, Sheila Ely, Ed Gaskins, Rob Harrington, George Housen, Judge Hill, Calvin, Ann Lloyd, Judge Julian Mann, Mike Mitchell, Judge Smith, and of course my colleague Darrell Miller and Amanda Lakoff. And I want to thank the members of give them a round of applause. I want to thank the public. I went to the public meeting in Charlotte, and that was, for me, a really great experience. You know, in the middle of a United States election cycle, which doesn't necessarily bring out the best, I found, remarkably, that this commission's work was bringing out the best in members of the public, members of the bar, and members of the community who came and were allotted 2 minutes to make a presentation. They didn't interrupt one another. Their comments were right to the point, and it was extreme. It was obvious to me how much the people of the state of North Carolina both appreciate the work of this commission and care about their courts and want to see the courts not just survive, but to succeed mightily. And that was inspirational to me. I also want to thank the many people, we sometimes call them stakeholders, but truly they're just citizens. And they came to our meeting and many of our meetings, and they shared with us their insights. And using those insights and our own experiences and studying the different areas of a very important area of life, our civil justice system, our committee, with the thought that our courts should be fair and accessible and efficient, came up with a number of recommendations. First of all, we support electronic filing. This is very important. Everybody supports electronic filing, but we have the perception that with electronic filing, we will see great changes in the way that we serve the public. So electronic filing and case management. Now one might think, oh gee, what's the big deal? You can go down to the courthouse and file a case, or you could do it electronically. One is maybe a little bit easier than the other, but that is like thinking that a rotary phone and an iPhone are really the same thing. And what you have with a smartphone is you have access to all the world's great libraries on your phone. You have databases. You have something transformational. And what we will have with electronic filing, and I will say that North Carolina was a leader in electronic filing and then now has become a follower and a laggard in electronic filing. What we will have, if we have electronic filing, is a database. And we will have the means for doing better, for analyzing how we are doing, and for being more efficient. Electronic filing not just makes the courts more accessible, but it makes them more efficient and self-conscious and self-aware. It gives them the tools to know how they are doing at any particular point in time. It permits a judge, instead of having to travel to a courthouse to look at papers, to absolutely just download them and look at them without engaging in travel. It permits lawyers to see where their cases are and to see how they've been decided, and to do the analytics that lawyers like to do now. It permits case management at a much higher level. So electronic filing is extremely important, and that is our first recommendation. The Assembly has given the courts the authority to develop rules once electronic filing is in place. And with that authority, we believe that the Chief Justice should appoint a standing rules committee. The rules of civil procedure that apply in any court are complex and require intense study. I've been involved in this on the federal side, and it takes years and years to develop the kinds of reforms that are needed, because there's so many potential collateral consequences every time a rule is changed. And it requires a lot of participation from the bar and the bench and others. It takes time. And you cannot do this every 20 years. This must be done on an ongoing basis because the law is dynamic, the legal profession is dynamic, the economy and our communities are dynamic, and they're constantly changing, and the law needs to change with them. So the appointment of a standing rules committee to engage continuously in law reform and in the improvement of the system so that it is fair and cost efficient for the litigants and for all involved. This is very important, and probably that with electronic filing will drive much reform in the coming years. As part of case management reform and consistent with the best practices that have been identified nationally, our committee recommends a system of case tracking that will separate cases into cases that are simple, no case is truly simple, but simpler, let us say, general or standard, and complex, and then to right-size the devotion of resources to those cases so that they're handled in the most efficient way possible. We suggest and ask that funding be restored for legal assistance programs such as legal aid and NC Leaf. Technology, and this is another one of our recommendations, can do so much to provide for access. But there are some cases where it is only a lawyer at the side of a litigant that can adequately address the situation. So we ask for restored funding for legal assistance at the same time that we recommend the increased use of technology throughout the system to increase and enhance access. And then finally, we suggest that there should be the appointment of a commission that would address and study in an ongoing way the way in which the civil justice system interacts with what I'll call issues of inequality. We've seen of late that there are ways in which the courts inadvertently, through civil fines and penalties, can contribute to a destitution pipeline. And I know that our Chief Justice does not want our courts to play this role. Judges do not want courts to play this role. And understanding what is happening to individuals who get caught up in a system where a fine that can't be paid then becomes a reason for imprisonment or other negative collateral consequences. This is very important, and we want to avoid that in this state. So, Chief and members of the committee, thank you for the opportunity to serve as your chair. We think these are important suggestions, and we hope that 20 years from now, if there's a new commission, people will look back and say, well done. Thank you.
One of the highest honors that an American lawyer or judge can attain during his or her career is election to the American Law Institute. And I am proud to share, for those who have not yet heard, that our own Dean David Levy will ascend to the position of president of the American Law Institute in May of next year. We'll next hear from Judge Bill Webb. Judge Webb has also done a masterful job at the helm of the Criminal Investigation and Adjudication Committee. That committee, as you all know, has taken on 4 discrete issues that will have an incredible impact on fairness and on efficient case management for the people of our state. Like Dean Levy, Bill brings with him an informed perspective from the federal courts to the committee's tireless service over the last few months due to Bill's service as a federal magistrate judge. Though he says he's retired, he still keeps a very busy schedule as an attorney, as a mediator, and most recently as a member of the UNC Board of Governors. We're very grateful for his work and leadership on this commission, and let's give Judge Webb a round of applause as he comes up.
When I saw the program and that I'd be following David Levy, my heart stopped. I've heard him speak before. I've been on programs with him, and it's a difficult and daunting task. Rather than call out the members of my committee, some of whom may not be here, I'm going to ask them to stand, because like the rest of you, I want to give them thanks. I want you to recognize them. They worked tirelessly as a group and in subcommittees. I'll say a little bit more about that later, but if the members of the Criminal Committee could stand and be recognized. Thank you. The Chief Justice put together a committee that was eclectic in every way you can imagine. We had defense attorneys, we had prosecutors, we had law enforcement persons, we had judges, we had court officials, and I thought it would be like herding cats. It was not. They worked in a way that was collaborative, and I think the results that we'll announce today will lead you to make the same conclusion. I'm not going to single out members of the committee, but I do want to thank the North Carolina Sheriff's Association. They drew the best out of all of us by constantly challenging us to provide information that supported our recommendation in the juvenile reinvestment area. It was difficult at times. It was tense at times, but we were always able to answer the questions they had, and their efforts strengthened the product that you'll hear about. I'd like to thank the Commission staff. They were particularly helpful when we needed resources. I'd like to thank, in particular, Jessie Smith. She's already been recognized, but I've never worked with a finer civil servant than Jessie. And as I told her earlier, I will not give her credit for the work of the committee, but she deserves credit solely for the writings of the committee. And I encourage you to read her report. It is as thorough and as fine an example of how one tackles problems and solves them as you'll find. I want to thank the Chief Justice for giving all of us a chance to serve our state. It was a tremendous honor to co-chair the commission, but it was a great sense of pride to watch us grow together as a team and address these issues. The Chief Justice charged us with identifying areas of concern in the state's criminal justice systems and making evidence-based recommendations for reform. And ladies and gentlemen, we did exactly that. The recommendations are as follows. Well, let me back up and tell you the process. Jessie organized us into a team-building exercise where everybody got little dots, and we talked about what issues were important. And then everybody put a sticker on the dot they thought was most important. And we took the four highest scores and decided that we'd focus on those. One was criminal case management, which Dean Levy's already talked about a little bit. We've got a very extensive case management system outlined in our report. It was the product of the National Center for State Courts, and the exact contours of it will be determined by how Justice Jackson's Technology Committee looks at that whole area. The area of pre-trial justice, bail reform if you would, the committee unanimously recommended that we have a pilot program that employs a risk assessment tool, much like what's being used in Charlotte, to determine the best way to help judges determine what conditions they should impose in addition to or instead of money bail. We started from the proposition that we would not ask that money bail be eliminated. It's been something that historically has worked. We think there are other ways to get more nonviolent offenders, particularly out of jail, without having to pony up a significant amount of money. We were happy that at the last session, we had the Bail Bonds Association come and talk to us, react to what we were proposing, and leave, I think, satisfied that this was an honest attempt to look at the best system we could marshal for our state. It's long been a goal of the court system to provide adequate defense for indigent defendants. We looked at the current IDS system. We looked at private attorneys on contract. We've looked at public defenders and have recommended a combination of those. We've recommended strengthening and improving the IDS system and other measures that will blend these three together that will, I think, offer the promise that defendants who cannot afford their own attorneys will be adequately and zealously represented in criminal court. And finally, the thing that I am most proud about is that we have made significant recommendations for raising the age of juvenile defendants. We did so with the endorsement of the Sheriff's Association, the Chiefs of Police Association, the Police Benevolent Association, all of the stakeholders who sat in our meetings, made contributions, in the end, said this is the thing to do. So we, hopefully, with the legislature's concurrence, will join the other 48 states in this country that treat 16 and 17-year-olds as children. One of the things that I learned and didn't know to begin with was that the resources are so much greater in the juvenile system. We were able to bring in the Department of Corrections and solve some of the problems. We're losing money today because we don't have sight and sound separation of juveniles and adults. Billy Lassiter from the Department of Corrections was able to solve some of those problems, to be a force multiplier in counties that have limited resources in the area of deputies. We're able to provide transportation to take a look at where do you house juveniles, and that alone will result in a significant increase in the amount of money flowing to the state from the federal government. More importantly, our children will no longer have to worry about criminal records being discoverable as they go through the juvenile process. Now, felonies A through E will still be treated as adult crimes. Rape, murder, violent robberies, those are the kinds of things that once we are able to raise the age, the legislature can look at and determine how best to handle. But today, we're on the threshold of treating juveniles as they should be treated, as juveniles, different from adults, housing them in different facilities, and sheltering them and giving them the kind of resources that will help them resume their lives. Thank you.
Well, you probably noticed that Judge Webb is a consensus builder, and I was amazed during the tenure of his chairmanship of this committee how the discussions began, and the committee grew together. They really showed us how civility can be restored in this country. They talked to each other and not past each other. And based upon that, they have come up with an excellent proposal. And I'm very proud of the Raise the Age proposal, and I will work very hard with the General Assembly and Governor to try to see this done. An interesting statistic that I was not even aware of, but that is over 90% of adults in North Carolina believe that the juvenile age is already up to 18. So we are not even up with the public in terms of how we are doing this. So let's get to work and get that done in the long session. So next up is our Legal Professionalism Committee. Now, most commissions like ours do not even include a discussion among attorneys as part of a commission that is within the judiciary. But we recognized early on that our court system can't talk about improving efficiency and access to our courts without including the critical role of the legal profession in that conversation. Catherine Arrowood has been the perfect fit to lead this committee. She has taken on her role as chair with gusto, which is good because her task was not simple. Getting a committee of 13 lawyers to agree on anything is a tall order. Thankfully, Catherine has plenty of experience as past president of the NC Bar Association. Her committee has produced a report that is almost certain to place North Carolina in the spotlight of the national conversation on the future of the legal profession. Catherine, you've done a marvelous job, and please join me in thanking Catherine as she comes forward. Well deserved.
Thank you. I want to start, as everyone has, by thanking first the staff. I mean, we had an awesome staff. I mean, every time I said, can we get so-and-so here? The answer was, let me see. And the next phone call I would get is, oh, yeah, they're coming. We just couldn't have done it without Will and all the others who helped us. I'm not going to ask my committee to stand up, but I wanted to say that I think we had the most fun committee. I don't know how you got all these fun people on my committee, but, I met some new people I didn't know before, and we worked together as a team, and we all had different points of view, but it was just a really, truly great experience. I did want to give a shout out to Lisa Shepard and Drew Erdachek. They have perfect attendance. Now, that is hard to do for busy lawyers, particularly Lisa, who came from Charlotte and didn't miss a meeting. But we had a very dedicated bunch. Our committee heard from over 14 outside speakers from all across the country. We also considered a very large body of research, and you will see that listed in the appendix to our report. There's a lot of information out there. And after getting through that and digesting all of that, we reached a few conclusions. We confirmed that we have a glut of unemployed and underemployed lawyers in this state. At the same time, we have many people who, both individuals and businesses, with significant legal needs that are going underserved or not being served at all. These two circumstances combine to create huge efficiency and financial challenges for our judicial system, and it blocks access to justice for many people. Fewer and fewer people can afford or need the highly specialized legal services that lawyers are being trained to provide. We noted that our present regulatory framework was put into place on the heels of the Great Depression in the 1930s and has remained largely unchanged. Some changes have been made, but largely unchanged since the Great Depression. The framework, in fact, does not specifically charge any entity with regularly scrutinizing or recommending changes as our society, the marketplace, and the courts change. And of course, change is happening very rapidly now. And so we're very much out of kilter between the supply and demand and the quality of the services that are available in this state. We are reactive and not proactive. And as a result of all of that, we finally came to the conclusion at our very last meeting that we should recommend the establishment of the North Carolina Center for Legal Innovation. And we would expect this center, hopefully established by the Chief Justice, to identify the changes needed, statutory and otherwise, that would address the following issues: the definition of the practice of law, the entities that are authorized to deliver legal services, the makeup, authority, and structure of the agencies that currently license the practice of law, and the criteria for admission to practice. The center should specifically consider how these changes will impact the courts, with an eye towards making our courts more user-friendly and our rules more consistent and accessible. Our system requires advocates who operate on the basis of facts and who exercise independent judgment in a manner that is free from conflicts of interest. So the center should continue and keep these legal professionalism goals in mind as it makes these recommendations. For without keeping that in mind, we will not make our court system work well, and it will not be a supportive part of our functioning democracy. I wanted to end by, again, thanking the chief for letting me serve. This has just been a real privilege. I had a terrific reporter, Matt Salchak, who's not here today, and if anybody knows Matt, I just relaxed. It was sort of like Bill having Jessica. I had the best, wonderful writer and very thoughtful, and helped us really to sort through the final details of the report. I also wanted to give a special thanks to both the State Bar and the Board of Law Examiners and the Equal Access to Justice Commission. Anytime we called on those three groups to give us information, they were there. I believe that Jennifer and Catherine Jean from the State Bar and Alice Mine collectively had perfect attendance at our committee meetings, and they were there to raise questions when we kind of were getting off the rails from time to time. And then last but not least, I wanted to give a shout out to Justice Orr. Where are you? I know I saw you come in. Back there in the corner. Anytime that we were not having a very lively session, we could count on Justice Orr to raise his hand and drop a bomb that then led to a very lively discussion. And that was actually part of what made the committee so great, is that we had people who were very willing to speak up with a point of view that they knew perhaps everyone in the room did not agree with. And that's, of course, how you make better decisions. So thank you, Justice Orr, for keeping us on the edge at all times. And thank you, Chief, for letting me serve.
I learned a long time ago that if you wanted something done right, that you called on Ms. Arrowood to help. So thank you so much for all you did. Brad Wilson led the charge for our Public Trust and Confidence Committee. Given that his day job as CEO of Blue Cross and Blue Shield requires a working knowledge of the healthcare industry and countless state and federal regulations, you must find the judicial branch pretty straightforward. The public's trust and confidence in our courts is at the very core of the Commission's work. And Brad's committee has served an important foundational role in the recommendation of each of our committees. Brad, we can only imagine how busy you have been navigating your role with this commission, as well as the many challenges you confront in your day job. Thank you for your service to our state through your leadership at Blue Cross and Blue Shield and as chair of the Public Trust and Confidence Committee. Please come up and share some recommendations from your committee.
Let me leverage and borrow from the thanks that has been issued before by the chief to all the commissioners and my colleagues as co-chairs. If nothing else, in the interest of time, I do want to, however, say a special thanks to Will and Mildred and Andrew, who were really the engine of our committee and made sure that I certainly kept a clear head and focus about the work that we undertook. And I also want to thank, as others have done, the vision and the energy that our Chief Justice has put into this effort. I'm confident that our work will henceforth be known as the Martin Commission, as it should be, and that one of the consequences of our work together will keep the judiciary in the constant conversation with policymakers in our state. I think one of the things that we all discovered is indeed a focus on the judiciary once every 20 years is not serving our state, and I hope that regularly now, henceforth, we will hear about the progress and evolution of the judicial branch. Our committee, let me share with you that we began our work by asking ourselves the question, well, exactly what type of confidence, if any, and trust, if any, does the public have in the judiciary? And we undertook, leveraging a couple of polls that were already about to go into the field, and we asked some questions and we learned some things. And so from that we distilled out the guiding principles under which all of our work was taken. And let me share those with you. That our judiciary needs to be accessible to the people. It needs to be efficient. It needs to certainly be fair and impartial. both in perception as well as in fact. Our judiciary needs to be accountable to the public. And last but certainly not least, we need to undergo a constant self-evaluation as part of stimulating and driving whatever public conversation will continue hereafter about the judiciary, so that we can really deal with the facts and we can also deal with perceptions. So out of these principles, we developed some recommendations. I'm going to keep them at a very high level. I obviously commend the entire report to your reading. But our first recommendation will focus around and center around ensuring well-qualified and independent judges in our state. And we believe that in order to do that and enhance, back to one of our principles, fair and impartial administration of justice, that a process needs to be examined by which the selection of judges and the retention of judges can be at its highest level. Recognizing that reasonable people can differ over the particulars of that, we look forward to working with everyone, including the General Assembly, to shape and form a process that will result in that result. We also believe that conducting a reoccurring public opinion survey is something that should be undertaken. There are plenty of opportunities to do that. We can keep the costs down, but again, that will keep our finger on the judicial pulse in North Carolina. We recommend, in order to continue to promote fair and equal access to the courts, that the judicial branch take steps to identify and remove barriers that impede fair and impartial access to our courts. And this includes not only legal and regulatory barriers, but physical impediments, cost factors, language issues, and the complexity of the judicial process. We were concerned about actual and perceived bias in the courts. That came clear through some of the survey results. And this will be the only data point that I will give you, because it was certainly interesting to me that 80% of the respondents believe that the wealthy receive better treatment, and 48% believe that white people receive better treatment than any other group. Now, we should be alarmed and disturbed by those statistics, and we can debate whether or not they're accurate, but that is the perception. So to that end, we have a recommendation that rallies around that in order to ensure a fair and impartial process and access, the judicial branch must acknowledge the potential of bias existing and to develop approaches and training for court personnel and other judicial officers on a regular and ongoing basis to recognize and rectify it and to identify how we can best get our arms around that. And last but not least, in this same area, that we need to work hard to ensure that the workforce of our judicial branch reflects the diversity of the people of our state. We've already touched on case management. It permeates virtually everything that we've done. I'm sure you're going to hear that from Justice Jackson. And so that we have encouraged and do recommend that the judicial branch evaluate methods and take actions that will yield just, timely, and economical scheduling and disposition of cases, that case management be studied carefully, and that the concept of a single judge having a case from beginning to end is something that should be explored, and that we leverage technology not only in that component part, but across our judicial system, such that it becomes not only more fair and impartial, but economical and expeditious. Chief, thank you for the honor that you have shown to me by giving me an opportunity to participate in this process, and I can assure you, indeed, leaving my day job from time to time and coming to what was an oasis for me was very rewarding. So now I've got to find something else to do. Thank you.
Well, I know it's not a secret to anyone, and this is a descriptive comment, not a normative comment, but several years ago, the United States implemented the Affordable Care Act. And so Brad has been implementing that mandate in our great state for a number of years, and now we understand that next year there might be another large document that arrives, and so that's right. Just as Brad and his company try to deliver the same equal uniform treatment to each and every Blue Cross customer, how could we not even much more so strive for equal justice in this great state? So, Brad, we thank you for all you've done to move us further and closer to that goal. Justice Barbara Jackson may have shaken her head in disbelief when I jokingly described our court system as relatively simple a moment ago. Justice Jackson chairs the Technology Committee, and she can tell you our judicial branch's technology is anything but simple. The topic of court technology systems can be intimidating, but that has not deterred Justice Jackson in her efforts during the commission. She's traveled around the country to court technology conferences. She's visited Texas to learn about their state court technology innovations. She has led roundtable discussions with chief justices and court administrators on the topic, and now that we are not having December court, she'll be on the road again to a national technology conference to even try to bring back more information to us. Justice Jackson has simply done a remarkable job of stepping up to lead the charge on major technology changes, which will be forthcoming in our courts. Please join me in thanking Justice Jackson as she comes forward. Oh, I love the computer.
Yeah, bring the computer, not so conducive to shaking hands, but it seemed appropriate. And I also, just so you know, I've been doing a little live tweeting today, so yeah, trying to get in the spirit of things. First, just like so many of us, just thank you, Chief Justice, for your vision in pulling together this commission and for the 5 committees that you established to take that vision forward. It really has been an honor to serve and really appreciate this opportunity so much. And thank you all for serving too. We all appreciate that. Thank you to the other co-chairs. As Dean Levy mentioned, it's been a great learning experience talking to you, and technology is a freestanding committee, but it is not something that is in and of itself an ends. It's a means to accomplish an ends, and I think all of the members of the Technology Committee recognize that, even though we're a freestanding committee. I want to thank the members of the committee too, and if you all could stand up and give everybody a little wave. You too. Really thank all these folks for their hard work. We met on a very regular basis since last year, and everybody's been there and participated and really given their all to what we're trying to accomplish, so I thank you all. Like everybody else, I want to thank our fine staff, the staff of the commission, Will, Emily, and Roxana, and also the staff at AOC, Jeff Marisek, Kurt Stevenson, who's been working with us as our reporter, has done a great job, and John Williams, who's also just integrally involved in all technology issues at AOC. And I know I'm leaving somebody out. Charles Fraley has helped with this, Brad Fowler. So many people at AOC have been helpful to this committee, and we really appreciate all the help and support you've given us. It's been tremendous, and again, we, like some of the other committees, have asked, can you bring somebody in? People have come in from Utah and other places to share with us how technology works where they are, and we really appreciate that. Oh, and Fred Wood, our CIO at the State Supreme Court and Court of Appeals. Definitely don't want to leave him out. So we had a little bit of an interesting charge with our committee because we were trying to accomplish a couple different things. And I'm now trying to pull it up. Here we go. In addition to the charge from the Chief Justice, we had a legislative charge. The legislative charge was to develop a 5-year strategic plan and to bring in an outside consultant to help us with the development of that plan. So at the beginning of 2016, we brought in Barry Dunn, who is an outside consultant to help us with that development. Some of you may have spoken to them. I know all the co-chairs had individual meetings with the Barry Dunn folks. They did surveys of members of the of stakeholders within the judicial system, and then a number of Bar Association folks were surveyed. And then there were a number of focus groups conducted, both within the judicial branch and also, again, with stakeholders outside the judicial branch. And we think that one of the reasons we liked them and one of the reasons we chose to go with Barry Dunn to help us develop this strategic plan was their collaborative approach. We really liked that they were having the give and take with members of the judiciary, with attorneys, with other stakeholders, and that they were going to listen to what we had to say. And we think that they did a really good job with that. We also had a lot of dialogue with them, and John Williams was definitely running point on that, and we appreciate everything you did, John. But ultimately, we came up with several recommendations, which we did not rank because they're all important. And some of them are going to go on simultaneously and are interrelated, and others of them are going to be fairly straightforward and can be implemented by the Chief Justice and AOC staff without any outside interference or outside support. So I'll just go through those briefly for you so you'll know what we've been doing. The first is governance, and I know this is Jeff Marisik's song. Currently, there's not an IT governance procedure in place, so that when folks come to our technical services division and ask for something, we don't have a set of guiding principles to say, this is something that we should do, this is the priority it should be given. So the governance model would put that kind of structure in place and would assist everybody within the court system in knowing what needs to be done, how it needs to be done, and ensure that a principled decision-making process is in place. The second one has to do with what we were talking about with you all, metrics. Identify what metrics to measure and run a baseline analysis, possibly using Court Tools, which is a National Center for State Courts tool that Barry Dunn worked with us on, or another standardization, so that we can take a look across the state and see how we're doing. And then once we've got those metrics, reporting and analytics. Once we know what we have, then we can start trying to use those reports and analytics to figure out how to improve. What are we doing right? What can we do better? What do we need to change? And then the fourth thing is the Enterprise Information Management System, and that's currently underway in Technical Services Division. Basically, that's a fancy name for document management. We're already working on that. Jeff and his shop have been hard at work for several months now, getting that in place, and that's really the foundation for electronic filing and case management, which are the next two items on our list. Of course, electronic filing, you go to the courthouse, you file your documents. And what we really envision with that is that it's a vertically integrated system where if you're going into district court or superior court, you're not going to have to come back and refile at the Supreme Court your whole record on appeal and compose it the way you do now. Something more, I think, analogous to what the PACER system does with the development of the joint appendix, where you can house your documents in that document management system and then develop your record on appeal that way and hopefully simplify things so we're not making more work for you and your clients if you're attorneys, or for judges or for clerks. Integrated case management will enable us to manage those documents once they're in the system. And then our financial management system, the current system is not great for the clerk's offices. It has a lot of redundancies. It has a lot of information that isn't there. And our new financial management system will integrate well with case management and our electronic filing system. Electronic public access. And the most important thing about this, too, is that electronic public access needs to be available on mobile devices. I personally refer to my mobile phone as the tether, because it's always with me and it's always got me chained to it. But I think we all really rely on those mobile devices now, and no matter what socioeconomic status somebody is from, generally they've got a mobile device. That's their portal to the world of information technology. Other options with that are potentially kiosks within courthouses or other self-service devices within the courthouse. If it's something, if there's a person who doesn't have access to a mobile device, they could still come in and self-serve and then take some of the burden off of clerks, because clerks right now spend a lot of their time answering fairly simple requests, and we can make that information available very simply through mobile devices or kiosks. Directions to the courthouse, information about jury duty, those types of things that I think will be very helpful. And finally, judicial workbench. And that's really broader than that. It's not just judicial workbench. It's judges, clerks, everybody within the court system will have a workbench where they can organize their day, perhaps write notes to another judge or to their law clerk, and manage their workflow through the judicial workbench. Those were the recommendations that we came up with through Barry Dunn. I think, you know, the scope of the work is broad, and it's going to be time consuming. I think that's something where we're all going to have to work to manage expectations. I know at a recent Administration of Justice Committee, I said that the horizon for electronic filing is probably 3 to 6 years. Am I probably in that ballpark is what we've talked about, maybe a little less? But it about put one of the attorneys in there into a coronary. But it is an extraordinarily complex process, what TDS is involved in. And if you think about it, with over 6,000 justice system employees, and the number of documents that will be flowing through the system, it's not an unrealistic time frame. I think we all just have such a hunger for moving into that electronic environment. We're ready. We are ready. We are all ready. And it's just going to take some time. So we need your help managing expectations, too. One of the things that's really great, though, that's going to be coming online hopefully relatively soon, we're getting very close to having a vendor for the redesign of our website, which, I use the website. I'm glad I know where I'm going on the website, because it's not an easy, intuitive website to use. So we've had discussions with a vendor. We're close to getting a contract with them. They recognize the importance of mobile first with access, because we know the current AOC website doesn't like to play well on the mobile phone. So we're really excited about that, and that's going to probably be one of the first things you'll see roll out, hopefully within about 8 to 12 months. And we will, of course, be soliciting more feedback, more beta testing and those kinds of things for the website, so we're really excited. But again, thank you all for your participation, and thank you, Chief, for including this.
Thank you so much, Justice Jackson, for all your work. And as you've already heard, she's getting ready to go to another conference on this topic, so thank you. Before I move forward, I am going to embarrass this individual, but our Chief Information Officer for the North Carolina courts is here with us today, Jeff Marisek. And Jeff came to us a number of years ago from the Pacific Northwest and has really brought a level of professionalism to our efforts, and we're really excited about working together to try to implement these technology recommendations. Jeff, stand up so we can give you a round of applause. Well, I hope you realize how much is contained in these recommendations. I think one of the more exciting aspects is how much we can do as a branch on our own, unilaterally, over the next several years with these recommendations. And then in other areas, we'll need to partner with the General Assembly, and that collaboration will begin at the first part of the year. Article 1, Section 35 of our state's Constitution instructs, and I quote, "A frequent recurrence to fundamental principles is absolutely necessary to preserve the blessings of liberty," end quote. When our state was formed over 200 years ago, the role of the courts was to protect people's rights by providing a fair and accessible forum for the resolution of their disputes. On several landmark occasions, our court system has recurred to these fundamental principles of fairness, accessibility, and effective management through commissions like this one. This commitment to periodic review helps the court system maintain its mission in an ever-changing environment. For a society to thrive, it must have a collective sense that fairness and justice prevail for everyone, regardless of wealth or status or heritage. These principles are unchanging. Our faith in these principles is rooted in the bedrock belief that they must be pursued in order to maintain the public's trust and confidence in our courts. It comes as little surprise that so much in our society has changed since the Medlin Commission's work 20 years ago. But then again, who would have thought that so much could change in our society in the last 15 months since your work on this commission began? These changes underscore the importance and urgency that our work has taken on. The way that our society has changed has also increased the readiness with which I receive the Commission's recommendations. From this spot over a year ago, I charged all of you with undertaking a comprehensive evaluation of our state judicial system and making actionable, real-world recommendations for strengthening our courts. You've met that challenge, and you set a brisk pace as you went about your task. 62 committee meetings, 4 public hearings, and over 4,000 volunteer hours later, you've produced a targeted action plan that will dramatically increase the fairness, accessibility, and effective management of our courts. I'm happy to report that we've already begun some of these recommendations. A good number of the recommendations fall squarely within the purview of the judicial branch for us to carry out unilaterally. A smaller number will require legislative action. In the coming weeks, I'll be communicating with legislative leaders to report on the work that the court system will be undertaking. I'll also be asking for their help for the recommendation that require changes in the law. Raising the juvenile age to 18 will be at the top of that list. About 2 years ago, I was in New York for a conference of Chief Justices, and my dear friend, the Chief Judge at that time of New York, Chief Justice Jonathan Lippman, he and I realized we were the final 2 states that needed to raise the age. And I hope I'm not violating any laws in saying that he and I kind of have a bet. And he was kind of using us to encourage his fellow New Yorkers to get New York to do the right thing. And now I'm going to use New York. Let's get ahead of New York, and let's get this done in the next session. Raising the age is a matter of fundamental fairness, and it's good policy, too. And even as I ask for data-driven solutions, Professor Smith, Judge Webb, that's exactly what you've delivered up. We know that only 3% of these offenses are serious felonies. And we know the other 97% are minor offenses for the most part, and situations where we need to work with that young person, help them turn their life around and become a contributing member of our society. Just 2 weeks ago, the Sheriff's Association endorsed the committee's recommendation on Raise the Age. And we are grateful to Eddie Caldwell, General Counsel of the Association, for his efforts. And as Judge Webb said earlier, this endorsement followed similar endorsements from the Police Benevolent Association and groups as diverse as the John Locke Foundation. I'm excited at the prospect that this long-sought change will come to fruition in North Carolina during the 2017 legislative session. And I hope that as we get to the first of the year, that each of you, as a commission member and as a citizen of North Carolina, will reach out to the General Assembly on this issue. It's an important issue, and it's one that we need to be successful on. Now, in response to the Commission's recommendations, we've also begun working to increase access to our courts. When our courts are too complicated, too costly, or simply too slow, citizens are denied meaningful access to justice. Our courts should always be places where the rule of law, not one party's superior ability to navigate arcane technicalities, or one party's ability to hire a lawyer when the other side cannot afford one, dictates the outcome in each and every case. Greater uniformity is key to improving access and administrative efficiency in our court system. With increased statewide uniformity comes a great responsibility for the state government to provide resources and leadership to continually adapt and improve. Otherwise, responsibility devolves to local judicial officials to try to improve their own local jurisdictions, and North Carolina's patchwork system of local courts in the 1950s showed what decentralized local control of the courts looked like. The Bell Commission resolved the tension between local control and statewide uniformity in favor of creating as uniform a system as possible. In order to provide meaningful access to justice in North Carolina, we must once again resolve that tension in favor of a system that's as uniform as possible. We've already begun the process of unifying the panoply of local rules found across our state. This will smooth the way for making standardized forms available statewide to self-represented litigants. Those forms are already being reviewed and enhanced, along with the nccourts.org website, which was long overdue for an overhaul, as Justice Jackson indicated. Uniformity of local rules will also complement the aspects of the Technology Committee's strategic plan, which will require uniformity in our business processes and data entry. Speaking of technology, AOC Technology Services Division is moving swiftly to begin implementing the strategic e-courts technology plan developed through the Technology Committee's work. As most of you know, our current technology platform consists of a hodgepodge of systems that too often aren't user-friendly. TSD has done a good job maintaining those systems. Now, with the legislature's increased support of our budget over the past several years, and with a strategic plan in place, our technology staff is poised to make great strides. Meaningful access to justice in North Carolina includes making our courthouses and court services available online so that we can minimize the need for the public to physically travel to our courthouses when possible. As I noted earlier, public trust and confidence in our courts is increased when we focus our efforts on improving efficient case management, fairness, and access. I've highlighted several of the Commission's recommendations that address fundamental fairness and meaningful access to our courts. But let's not forget the need to provide timely dispositions through efficient case management. Both the Civil Justice and the Criminal Investigation and Adjudication Committees have made recommendations that will significantly improve how we manage cases. By allocating valuable court time for meaningful events, we can better respect the public's time and steward our judicial resources. This need for improving the court's performance has been echoed by the Public Trust and Confidence Committee. An important first step toward improving our case management is to begin using measurements to assess how we're doing. We'll provide that data back to local officials as a tool that they can use. Our ability to collect meaningful data is currently limited by the condition of our technology and by inconsistent data collection methods in local jurisdictions. Our ability to measure and assess court performance will improve hand in hand with improvements in technology and the effort to increase uniformity. Meaningful measurement of court performance will lay the groundwork for regular training and best practices, and will provide the momentum for innovative case management approaches, such as case tracking. Measurement training will go beyond case management, however, and it will include efforts by judicial officials and staff on improving procedural fairness for the court system's users and training on issues such as cultural awareness and implicit bias. How will we know if we're succeeding in making improvements to our courts and increasing the public's confidence in our courts? We'll start by periodically asking the public how we're doing through public polling. We don't need to wait 20 years. We'll also craft surveys to ask court system users, both online and in person at the courthouse, about their experience. Internally, we'll review data on court performance. I know I've only scratched the surface of the steps we've taken and still have to take in response to the Commission's recommendations. There's obviously a lot more to be done, which brings me to this observation. There's much to be done in part because it's been 20 years since we've undertaken a comprehensive review of our court system. The judicial branch's mission is too critical to wait another 20 years to see how we're doing. Our judicial officials collectively have a duty to this state to identify and respond to issues affecting the administration of justice in North Carolina. There's currently no process or mechanism for this. 3 of this Commission's committees have recognized this need within their areas of inquiry and have recommended an oversight group in some form or another. Civil Justice recommended a Civil Rules Committee, Criminal recommended an advisory board for criminal case management, and Technology recommended a governance board for identifying and prioritizing technology initiatives. In response, in the coming months, I plan to put in place an advisory structure composed of several committees that will provide ongoing guidance and advice on the administration of justice in our state. Of course, the first task of these advisory committees will be to advise on how to implement this commission's recommendations. But beyond that, this structure will enable the judicial branch to make ongoing course corrections and improvements as we continue the important work of administering justice. In the next 2 months, Commission staff will be putting the finishing touches on the final report. Once the reports are in hard copy, we'll have a small ceremony of sorts so that I can officially receive your recommendations. We'll notify you ahead of time of that event once it's scheduled in January. I've also instructed the Commission staff to mail each of you an advance copy of the report as soon as it's available, kind of hot off the press, so to speak. We'll need your support in the spring as goodwill ambassadors of the Commission's work. So here we are at the end of this incredible process, and here we are at the beginning of another incredible process. You have met the challenge that I gave you in September of last year to represent this generation's duty to guard the rule of law and our imperative to administer justice. I reiterated that challenge in January, that we not, as President Teddy Roosevelt said, be among those cold and timid souls who neither know victory nor defeat. You've stepped into the arena, you've striven valiantly. You have indeed spent yourselves in a worthy cause, and you know the triumph of high achievement. Thank you again for all of your hard work, persistence, and dedication to the administration of justice in North Carolina. Now, I will tell you that everybody here deserves an award. It's amazing what everybody in this room has done over the last 15 months. But I think we can observe that not everybody is retiring this week. Now, let me ask Will or Andrew, do you have what I need to present this award? Ah, well, I'm proud of my chief of staff. At least he realized he needed to go and find that. Well, I looked down and all of a sudden I panicked. I will tell you, I was at one of the gubernatorial inaugurations. Come on up. While Will is walking up, we were sitting behind the stand at a gubernatorial inauguration. And as you know, the members of the Supreme Court help with the installations. And all of a sudden, nobody could find the Bible. And so talk about panic. But in her usual stellar way, former Chief Justice Parker realized the problem. And she started looking around and she said, I think in that drawer. And you should have seen how quick that staffer ran up to that drawer. And yes, lo and behold, the Bible was right where Chief Justice Parker thought it was. So we were able to work out of that situation. Well, Andrew, you have certainly earned your pay as Chief of Staff today. You know, some of my most incredible memories in life have been working with fellow justice system stakeholders across this great state. And you really see just incredible people who work in our courthouses, who help the citizens. As you know, oftentimes we see the next case and we realize that to this citizen, that may be the most important case to them, the most important interaction with the state government they will ever have. And there's an individual with us today who has had a very distinguished career. He actually started out as a professional football player. But he did not stop there. He worked in the trenches of our legal system as a probation and parole officer. And then he convinced the citizens of Cumberland County to elect him as sheriff. And that was a long time ago. He became sheriff in 1994. And I think he's conceded probably that first election was the most challenging. Since that time, nobody has, well, people have dared to run against this individual, but they haven't polled many votes. But for his outstanding service to the judicial branch of North Carolina as Sheriff of Cumberland County and as a member of the North Carolina Commission on the Administration of Law and Justice, I do hereby enter judgment and confer upon Sheriff Earl Moose Butler the title of Friend of the Court. Sheriff Butler, could you please come forward?
Thank you so much, and I'll just say, kind of after 50 years, I was telling the Chief Justice, I've been hanging around courthouses and probation parole for 30 years and sheriff for 22, so I think it's time to go home and let someone else enjoy it. But I've enjoyed the committee. I've enjoyed working with a lot of great folks, and as the Chief Justice, it's been my pleasure to know him well and to be a party of him and support him and Brad and all the group here. We just appreciate you so much, and I see a great court system improving it, and I think, as everyone knows, we all know that we need to improve our court system, and the juvenile justice part really needs to be dealt with severely. Thank you so much.
Well, I want to thank everybody for coming to the Judicial Center. I know how busy everyone's life is, particularly as we approach the holidays. So I know we'll be in touch in the weeks and months ahead. Please know that as Ross Perot said at one time, I am all ears as we move in to this implementation stage. So please call me personally if there's any mid-course correction we need to make. And let's work together to ensure equal access to justice to each and every North Carolinian. Thanks again for coming. Have a great weekend.